Hi, I'm Gabrielle, and I've made this brief video to answer the question: what is a work of artistic craftsmanship, with reference to the case of Coogi Australia and Hysport International? Section 32 of the Copyright Act states that copyright subsists in artistic works. Section 10 of the Act defines artistic work to include paintings, drawings, buildings, and works of artistic craftsmanship. As it is not defined in the Copyright Act, we must delve deeper into the common law to discover what exactly constitutes a work of artistic craftsmanship. In the case of Coogi and Hysport, the applicant Coogi designed and produced machine-made knitted fabrics. One of these fabrics consisted of a sophisticated three-dimensional, multicoloured stitch design. Coogi alleged that a competitor, Hysport, had infringed copyright by producing garments that were made from a complex fabric similar to Coogi's design. Coogi asserted that their stitch design was an artistic work capable of protection by the Copyright Act because it was a work of artistic craftsmanship. However, Hysport claimed that as the stitch was used for the purpose of mass production, it was not artistic craftsmanship and therefore was unprotected by the Copyright Act. Justice Drummond found that pursuant to Section 22 of the Copyright Act, copyright only subsists in an original work when the work is first reduced to some material form. As a result, the Coogi fabric was found to be a work of artistic craftsmanship, but only for the very first run of fabric in each of the 7 colours in which it was produced. In reaching his decision, Justice Drummond put forward a number of valuable propositions that have shaped the way a work of artistic craftsmanship is identified by the courts. Firstly, His Honour found that the work must have an element of real artistic or aesthetic quality. This level of aesthetic appeal is an objective test to be assessed by the court, who may refer to expert evidence to determine whether the work has more than mere visual appeal. Secondly, Justice Drummond contradicted Justice Pape's finding in the earlier case of Cuisenaire and Reed, where the intent of the creator was a key factor in determining whether a product was a work of artistic craftsmanship. Instead, Justice Drummond found that while the court may consider the creator's intention, it will not determine whether a product is a work of artistic craftsmanship, as the creator may have failed to realize their intent. Thirdly, Justice Drummond found that a product may still be a work of artistic craftsmanship even if it is capable of mass production. The creator of the material in Coogi was a highly experienced designer and manufacturer in the knitting industry who used sophisticated computer-controlled machinery to produce the design. While this work was not handcrafted, it was found to be a manifestation of pride in sound workmanship and an exercise of a skill demonstrating his training and knowledge. The creator was therefore described as a craftsman and his work artistic craftsmanship. In summary, we will consider what this means for artists. If your product has artistic or aesthetic appeal that may be determined objectively by the court, if the manufacturing process could be considered to be a manifestation of pride in sound workmanship and an exercise of skill and knowledge by the creator, regardless of whether it was handcrafted or capable of mass production by machine, the first manufacturing run of your product may be considered a work of artistic craftsmanship, allowing you to enforce your copyright against infringement. So there you have it. The court will consider the aesthetic and artistic quality of your work, as well as the skill, knowledge, and workmanship that contributed to its creation. It is these key factors that determine whether your work constitutes artistic craftsmanship.